When William becomes king, 5 questions about Camilla's future will require separate answers. Her title, her constitutional position, her property and residence, her money, and her security will not all follow the same rule. One statutory eligibility will end under current law. One historical description will remain relevant. Her future use of an official residence will have no predetermined answer, and no reliable record shows that William can, or intends to, take everything from her. The confusion begins when title, power, property, money, and security are treated as if they were the same thing. They are not. Each follows a different rule, and each leaves William with a different amount of influence. The strongest viral claim says a new king could strip Camilla of her title, remove her from every royal home, end every source of support, and reduce her to a private outsider with a single command. That claim sounds clear because it collapses an entire constitutional transition into one personal confrontation. The documents tell a more consequential story. Some changes happen without William choosing them. Some decisions belong to the new royal household. Some depend on Parliament or public authorities. Others remain governed by private law. This royal proof investigation will test the major claims against Acts of Parliament, official succession information, royal finance guidance, palace property records, and historical precedent. For every issue, we will follow the same chain. The viral claim. What the record actually says, the document or precedent behind it, the verdict, and why it matters. The conclusion applies to the normal succession scenario in which King Charles dies while still married to Camilla and she survives him. It is not a prediction about timing, health, or private family relationships. It is an explanation of the rules available in August of 2026. The 4 royal proof classifications will guide the investigation. Automatic means current law or constitutional practice supplies the answer. Precedent means history shows that an outcome is possible without making it inevitable. Not yet known means the responsible institution has not announced the future arrangement. Unsupported means the claim goes beyond the available evidence. These labels are not a device for avoiding a conclusion. They identify which decision-maker, document, or rule actually controls each part of the story. The first viral claim is that Camilla loses everything the moment William is crowned. The record begins earlier than the coronation. Official royal family information on accession explains that a new sovereign succeeds as soon as the previous sovereign dies. The Accession Council formally proclaims what has already happened. A coronation may follow months later, but it does not create the reign. This sequence is easy to misunderstand because the public ceremonies arrive in stages. The death of the sovereign ends one reign. Succession begins the next one immediately. The Accession Council then meets, usually as soon as practical, to record and proclaim the identity of the new sovereign. Public proclamations carry that announcement beyond the council. The coronation is a later religious and ceremonial event. None of those later acts fills an empty throne, because constitutional continuity does not wait for the ceremony. The accession of Charles provides the clearest modern demonstration. He became king when Queen Elizabeth II died. The council that followed did not elect him and did not grant him the crown. Its proclamation recognized a succession that had already taken place. The same principle applies to William if he remains the lawful heir when Charles dies. The practical consequence is immediate. There is no period in which Camilla remains the current queen consort while everyone waits to see whether William accepts the role. Her position changes at the same legal moment as the identity of the sovereign. The first major answer is therefore automatic, but it settles only the timing. It does not settle her future style, residence, work, or finances. In that instant, William becomes king. Assuming William and Catherine remain married, Catherine becomes queen consort. Camilla is no longer the consort of the reigning sovereign, but that does not erase the fact that she was queen during Charles's reign. Catherine's change is not a promotion that William would need to negotiate with Camilla. Under the traditional rule, the wife of a reigning king is the queen consort. The future royal household would determine the exact language used in public communications, but Catherine would occupy the consort's current institutional position. Camilla would stand in relation to the previous reign. That simultaneous change explains why the question cannot be reduced to whether William likes or dislikes his stepmother. The constitutional system has room for the widow of one king and the consort of another, but it does not treat them as holding the same office. One looks backward to a completed reign. The other supports the reigning sovereign. The document settles who moves into the current role, but it opens a more difficult question about the woman who leaves it. That sequence creates two very different uses of the word queen. Catherine would be the consort of the new sovereign. Camilla would be the widow of the previous sovereign. Only Catherine would occupy the current constitutional position beside the king, even if both women continued to carry queen within their public styles. Historical language gives her a new category. A queen dowager is the widow of a king. Camilla would fit that description, but she would not be the queen mother because she is William's stepmother rather than his mother. Three expressions are often merged here, even though each answers a different question. Queen consort identifies the wife of the reigning king. Queen dowager describes the widow of a king. Queen mother describes a widowed queen who is also the mother of the current sovereign. Camilla can fit the second description in the ordinary succession scenario, but she cannot fit the third description in relation to William. Queen Mother is also not an automatic rank that every royal widow adopts. Queen Alexandra was the mother of King George V, yet official documents continued to call her Queen Alexandra. Queen Mary was the mother of two kings, but she remained Queen Mary. Queen Elizabeth adopted the form Queen Elizabeth, the Queen Mother, after her daughter became Queen Elizabeth II. That wording distinguished two living women named Elizabeth, while also describing their relationship. The distinction is not ceremonial trivia. If Camilla were inaccurately called the Queen Mother, audiences might assume a constitutional and family position she does not possess. If she were described simply as a former queen, audiences might assume every part of her rank had vanished. Queen Dowager is useful because it identifies continuity and separation at the same time. She remains the widow of a king, but she is no longer the current king's consort. There is a document behind that distinction. Parliamentary records from 1837 referred to Queen Adelaide, the widow of King William IV, as the Queen Dowager after Queen Victoria succeeded to the throne. Other widowed consorts, including Queen Alexandra and Queen Mary, continued to be known publicly by their names. Queen Adelaide is especially relevant because she was not Victoria's mother. Her position therefore resembles Camilla's more closely than the Queen Mother's position resembles it. The parliamentary address proves that Queen Dowager was accepted language for a royal widow living under a new sovereign who was not her child. It does not prove which words a palace communications team will choose almost 2 centuries later. Official publication also shows how two queens can be distinguished without stripping the widow of her name. A London Gazette record from 1910 referred to Her Majesty Queen Alexandra and, separately, Her Majesty the Queen, meaning Queen Mary. After George V died, another Gazette record continued to refer to Her Majesty Queen Mary. These are primary examples of a widow keeping queen within her public style, while another woman occupied the current position. The strongest viral version claims William can erase Camilla's title with a private order. The records support a narrower conclusion. A parliamentary analysis of the earlier proposal for Camilla to use the style princess consort noted that a public style could differ from the legal position, and that legislation would have been needed to prevent her from being queen when Charles became king. That episode concerned her status as the wife of a reigning king, not the exact form she may use as a widow. It nevertheless shows why a palace preference and a constitutional status cannot always be treated as the same thing. William and the future household may influence how Camilla is described in day-to-day official communication. Government and parliament may become relevant if anyone attempted a more fundamental legal change. No modern precedent tells us that a king acting alone can delete the status produced by his predecessor's lawful marriage. The evidence, therefore, blocks both extreme claims. Her future wording is not fixed, and her past cannot be administratively rewritten. That precedent supports describing Camilla as a queen dowager. It does not reveal the exact style that a future royal household would use on invitations, websites, or official announcements. She might continue to be known as Queen Camilla, but no future public style has been announced. This is where disciplined uncertainty becomes more useful than a dramatic prediction. The best supported category is clear enough for the investigation. The future style is not. Royal proof can show the historical pattern, identify the closest records, and explain the authority available to a new reign. It cannot publish an announcement that the future royal household has not made. Calling Camilla a queen dowager describes her relationship to the previous reign. It would not make her a second queen consort or place her above Catherine in William's household. The royal proof verdict is precise. Queen dowager is the best supported historical category, while the exact public wording remains unsettled. Why does that matter? Because a title is not the power she would actually lose. The second viral claim says Camilla would either retain constitutional authority over William or lose it only if he personally removed her. The record says neither. As queen consort, Camilla is not a joint sovereign. She cannot make laws, direct ministers, command the government, or overrule the king. Her relevant statutory position comes from being the sovereign's spouse, not from possessing part of his office. The document is the Regency Act of 1937. Section 6 places the sovereign spouse within the group eligible to serve as counsellors of state, together with qualified people nearest in the line of succession. The law matters because it identifies a real function that can be measured. It is not a vague claim about influence behind palace walls. Even that function is frequently exaggerated. Eligibility is only the first gate. Counsellors do not wake each morning with a share of the royal prerogative. The sovereign must formally delegate specified functions through an official instrument when the legal conditions are met. The authorization defines what can be done, and the functions are normally exercised jointly. The arrangement exists to maintain continuity when the sovereign is temporarily unavailable, not to create several substitute monarchs. In practice, authorized counsellors may deal with necessary constitutional business, such as holding a privy council meeting, receiving diplomatic credentials, or signing routine documents. But the delegation can be restricted, and the original act reserves important matters. The person who is eligible is therefore not identical to the person who is actively exercising a function on a given day. That distinction dismantles the claim that Camilla presently governs alongside Charles. Camilla qualifies now because she is Charles's wife. When William becomes sovereign, she is no longer the sovereign's spouse. She is not among the eligible people nearest in the line of succession who fill the statutory places. Catherine, assuming she remains William's wife, becomes the spouse who qualifies under that part of the rule. Camilla's eligibility ends through the operation of the statute itself. William would not be confiscating a power or signing an order against her. One later Act of Parliament proves why widowhood alone is not enough. When George VI died, Queen Elizabeth, the Queen Mother, stopped qualifying through marriage to the sovereign. Parliament then passed the Regency Act of 1953 and added her by name for the rest of her life. If being the widow of a king had preserved the position automatically, that special provision would have served no purpose. The precedent is especially valuable because it separates public rank from statutory eligibility. The Queen Mother retained enormous status, yet status alone did not put her back on the legal list. The Counsellors of State Act of 2022 supplies the modern comparison. Parliament added the Princess Royal and Prince Edward by name for life. The change expanded the available pool while preserving the underlying system of formal delegation. It did not create a future exception for Camilla. It also shows the route that would be required if a future government wanted to include her. Parliament could pass another law. William could support or approve such a proposal through the constitutional process, but a private promise from the king could not amend the existing list. This is also why the word removed is misleading. Camilla would not be singled out from a position that otherwise lasts forever. The condition that places her on the list would cease to exist. Her historical title might continue, her charities might continue, and the new household might still treat her with exceptional prominence. None of those facts would restore a statutory qualification that Parliament tied to a different relationship. Under current law, this change happens automatically. Camilla's qualification as the sovereign's spouse ends, while any decision to add her again would need legislation. This is the clearest constitutional loss in the story, and it requires no feud, punishment, or palace confrontation. The third viral claim is more dramatic. William becomes king, expels Camilla from the royal family, and removes every public role she has. No official record supports the claim that he plans to punish, humiliate, or banish her. More importantly, expulsion from the family is not a single legal procedure waiting for a monarch's signature. Family relationship, public style, constitutional eligibility, official employment, charitable patronage, residence, and private citizenship are different things. A headline can combine them. The law does not. What the record does support is a narrower and still significant form of influence. A new sovereign leads a new reign, supported by a royal household organized around that sovereign's duties. William and the new household would shape who formally represents him, which engagements receive staff and travel support, how public appearances are coordinated, and whether Camilla continues any regular service connected to the crown. That authority would be practical as well as symbolic. An active working royal needs a calendar, private secretarial support, access to official briefings, transport, communications, and a defined relationship with the sovereign. Those arrangements do not continue forever merely because they existed in the previous reign. A widow may remain prominent, but the new household must decide which work belongs to the new reign and how it will be supported. 3 outcomes are therefore possible without any of them being evidence of a feud. Camilla could be invited to retain selected charitable and ceremonial duties. Her schedule could be reduced to a small number of occasions connected to Charles's memory or her established causes, or she could largely retire from public life. The decisive fact is that no future program has been announced. A responsible investigation can define the choices, but it cannot pretend that one has already been made. Patronage requires another distinction. Some associations are personal relationships between a public figure and a charity. Others carry particular royal or institutional significance. A charity may wish to continue an association with Camilla even if she no longer represents the sovereign on a regular schedule. Camilla may agree or decline, and the new household may review how the connection is described. A surviving list of patronages would not prove that she retained constitutional authority. A reduced royal calendar would not automatically cancel every charitable relationship. Public precedents could change as well. Catherine would be the current queen consort and the senior woman serving beside the sovereign. Camilla's place at state occasions, processions, family ceremonies, and formal communications would be determined for the new reign. Those choices can materially reduce visibility without altering the historical fact that she was Charles's queen. This is where institutional power is strongest. not in erasing the past, but in deciding who stands at the center of the present monarchy. William's influence would still have legal limits. Being king would not allow him to confiscate Camilla's private property, cancel valid contracts, disregard trusts, deprive her of citizenship, or exile her from Britain. Where royal powers have legal effects, the modern sovereign normally acts through established constitutional processes and, where required, ministerial advice. The crown is an institution under law, not a private enforcement mechanism for family disputes. The evidence supports a two-part conclusion. William could strongly shape Camilla's future as a working member of the monarchy. He would not gain unlimited power over her as a private person. That boundary becomes even more important when the dispute moves from status to the keys of a royal residence. The next viral claim says William could personally seize every palace from Camilla. A competing claim says she would possess a guaranteed right to remain in Clarence House for life. The record supports neither certainty because royal residence is not one legal category. The Sovereign Grant Guidance explains that the occupied royal palaces are held by the sovereign in trust for the nation. They are maintained for the monarchy and its successors. They are not ordinary private houses that the monarch can freely sell, mortgage, or leave to a relative. The king occupies a constitutional position in relation to them, but that does not make every room his personal property. Official financial records include Clarence House within the occupied royal palace's estate, and the royal family describes it as an official royal residence. That places the building in a different category from a house bought and owned by an individual. Camilla's present use is connected to the current reign and to the official household she shares with Charles. It is not public evidence of a deed in her name or a guaranteed life tenancy. The Crown Estate is different again. It manages a large property portfolio under statute and returns its net revenue to the Treasury under the established financial system. The sovereign does not treat that portfolio as a private collection of houses. Property held through the Duchy of Lancaster or the Duchy of Cornwall follows its own rules. A privately owned estate follows ordinary property and inheritance law. A leased home depends on the lease. An official apartment may depend on a license, administrative allocation, or the performance of duties. Calling all of them royal property conceals the question that actually decides the outcome. A National Audit Office investigation published in 2026 makes that distinction unusually visible. It examined residential arrangements involving different providers, including the royal household, the Crown Estate, and the duchies. The investigation found that terms vary according to the provider, the property, the resident's role, and the agreement in place. Some working members of the royal family occupy accommodation without rent because the residence supports their duties. Some arrangements for people who are not working royals involve rent. Security limitations and the unusual nature of the property can also affect what a comparable market arrangement would mean. Those findings do not establish Camilla's future terms. They do something more useful. They show the sequence of questions that must be answered. Who legally controls the property? Who manages it? Is occupation linked to duties? Is there a written tenancy or license? Who pays for maintenance and private living costs? Does the security environment restrict alternative use? Only after those questions are answered can anyone explain whether continued residence is a right, an institutional decision, a rental arrangement, or a private benefit. Clarence House, therefore, cannot be treated as a suitcase that automatically passes from one family member to another. In a new reign, the sovereign and the royal household would have substantial influence over the allocation of official accommodation. They might decide that continuity is appropriate for a royal widow. They might arrange a period of transition. They might offer another residence better suited to a reduced role. They might create terms that separate official space from personal costs. Each option is institutionally possible. None has been announced. The language of eviction is equally premature. There is no publicly documented lifetime right guaranteeing Camilla the use of Clarence House. But absence of a published guarantee is not evidence that removal has been planned. Official accommodation is often governed by arrangements that are more complex than a newspaper headline can show. A future decision may combine respect for the previous reign, the needs of the new household, security, maintenance, and Camilla's willingness to continue public duties. Now change the property, and the answer changes with it. Balmoral and Sandringham are commonly discussed beside Buckingham Palace, yet they are private royal estates rather than occupied royal palaces held in trust for the nation. Birkhall is part of the privately owned Balmoral estate. Rights involving those places would depend on private ownership, a will, trusts, permissions, or other valid arrangements. Their royal associations do not turn them into sovereign grant property, and their private status does not tell us who will receive or occupy them after Charles. This is where claims about a guaranteed retreat for Camilla become unsafe. A person can have access to a home without owning it. A property can be held through trustees. A right of occupation can differ from the beneficial ownership of the underlying asset. None of those details should be invented from photographs of Camilla using a residence. Land records, trust documents, or a valid estate instrument would be needed to make a precise claim. Anything lawfully owned by Camilla remains subject to ordinary property law. Anything privately owned by Charles would pass according to estate arrangements that are not fully public. Anything held for the institution remains governed by the structure that holds it. William's accession would not collapse those three categories into one royal possession. The records leave Camilla's future official residence unresolved. William and the household could influence the result, but legal control, administrative policy, security, financing, and any valid private arrangements would all matter. The strongest claim about instant expulsion is therefore also the claim with the least documentary support. The money question then introduces another boundary that most royal videos ignore. One viral version says Camilla would keep a permanent taxpayer-funded salary. Another says every form of public support would disappear at the instant Charles's reign ended. The sovereign grant guidance says something more specific. The grant supports the monarch's official business. It pays for functions such as household staff, official travel, and maintenance of the occupied royal palaces. Annual accounts identify institutional expenditure and are audited. The system does not divide a public fund into personal shares owned by individual relatives. Camilla, therefore, does not possess a personal slice of the sovereign grant that can follow her into the next reign. Her present engagements are supported because they form part of the work of Charles's monarchy. If she performed duties approved within William's household, legitimate staff, travel, and operating costs connected to that role might continue to receive institutional support. If she retired, the basis for those expenses would narrow or disappear. That is a change in funded activity, not the confiscation of a salary. The transition itself is not as abrupt as the viral story suggests. The sovereign grant legislation includes continuity machinery, and the current duration order extends the relevant arrangement for 6 months after the end of Charles's reign. That provision is designed to keep the institution functioning while the new reign establishes its financial framework. It does not award Camilla 6 months of personal income, and it does not predetermine whether she will have a public role under William. The distinction becomes clearer with a simple test. If the household pays for travel to an engagement performed on behalf of the sovereign, that is an official cost. If an individual buys a private possession or pays an ordinary personal bill, that is not transformed into official expenditure merely because the person has a title. Accommodation may contain both institutional and private elements, which is why audited accounts and property policies separate maintenance responsibilities, official use, and personal living costs. Private financial support belongs to another system. The sovereign has access to private resources associated with the Duchy of Lancaster and the Privy Purse, but those terms do not describe a public pension belonging to Camilla. William might choose to provide private family support within the law. Charles might make private provision through a will, trust, gift, or right of occupation. Camilla may possess assets of her own. None of those possibilities reveals an amount, and none should be reported as an agreement already signed. Royal estate documents introduce a final obstacle to certainty. The public does not have the complete terms of Charles's future will or any relevant private trusts. Senior royal wills have historically been sealed through a judicial process, with a procedure for possible review after 90 years. That practice limits immediate public inspection. It does not prove that a secret asset exists. It means the documentary evidence needed to name beneficiaries, and property may not be available when a succession occurs. The responsible conclusion is deliberately narrower than the rumor. No verified document establishes a guaranteed pension for Camilla, a promised collection, a named bank account, or a fixed settlement. Equally, no document proves that she will be left without private resources. The absence of public terms supports an unknown classification, not either extreme. Security is separate again, both financially and administratively. Official sovereign grant accounts state that physical security is excluded from grant expenditure. Government policy also avoids publishing individual protective arrangements or their detailed cost because disclosure could compromise security. That means a viewer cannot calculate Camilla's future protection by finding a line in the household's ordinary operating budget. Any publicly funded police protection would be considered by the competent government and policing authorities under the applicable security process. Threat, role, location, and operational assessment may be relevant, but the individual decision and its reasons are not available for this future scenario. Remaining a prominent royal widow would not itself reveal the precise package. Retiring from engagements would not prove that every risk had vanished. William could express concerns, and the household could coordinate with the authorities. He could not personally determine the complete police assessment, announce its sensitive details, or convert protection into a reward for loyalty. Security is not a ceremonial privilege that can safely be switched on or off for dramatic effect. The evidence, therefore, produces three separate answers. The sovereign grant is not Camilla's personal salary. Support for future duties would depend on a role and the new household's arrangements. Private provision and protective security are governed through different systems whose future details remain undisclosed. Saying only that Camilla is funded hides the decision-maker behind each pound and the purpose for which it may be spent. Before turning to her children, private inheritance needs one final test. Place every asset into one of three baskets. The first basket contains property that Camilla already owns or valid rights created for her. Accession does not transfer those assets to William. The second contains Charles's private property. A will, trust, gift, joint ownership arrangement, or other lawful instrument may determine what happens to it. William becomes sovereign, but he does not become the author of Charles's will. The third basket contains assets held for the crown or for institutional purposes. Those do not enter Charles's ordinary private estate merely because he used them during his reign. This test prevents a common error involving jewelry, art, houses, and collections. The fact that an object is associated with Charles does not establish that he owns it privately. It may belong to the royal collection, a trust, the institution, another family member, or a private estate. The owner must be identified before any beneficiary can be predicted. A will can transfer only what the person making it is legally able to transfer. The same caution applies in the other direction. Private property does not become crown property merely because its owner becomes king. Official information identifies Balmoral and Sandringham as private estates, distinct from assets held by the sovereign for the nation. Their royal history does not erase private property law. Their future after Charles would still depend on valid estate arrangements, not on the public, assuming that every royal asset passes to William in the same way as the throne. The three baskets do not tell us what Camilla receives. They tell us why confident lists of her future inheritance are unreliable. Her own property remains hers. Charles's private estate follows lawful but undisclosed arrangements. Institutional assets stay within the structure that holds them. Any more specific answer needs a document that has not been made public. The same boundary applies to her children. The viral claim is that Tom Parker Bowles and Laura Lopes become royal heirs or gain access to crown property because their mother was queen. Marriage to the sovereign does not place a consort's children from an earlier marriage into the line of succession. The succession follows legal rules of descent, not the public rank acquired by a parent through marriage. Tom and Laura are not descendants of Charles, and William's accession would not alter their relationship to him. They acquire no place through their mother's marriage, and they do not move upward because she becomes a widow. The title question produces the same answer. Being the adult child of a queen consort does not automatically create a prince, princess, peerage, or constitutional office. Charles could not make them royal heirs merely by treating them as family, and William would not need to remove a status they never possessed. Their public association with the monarchy may be socially important, but social proximity is not constitutional membership. Crown property is even further removed. Assets held for the sovereign and successors do not become part of Camilla's private estate, so they cannot pass through her to her children. Tom and Laura could receive private property through lawful gifts, wills, or family arrangements, just as other private individuals can. They might also receive nothing from a particular estate. Without authentic ownership records or testamentary documents, no one can responsibly identify a house, piece of jewelry, collection, or amount of money that either child will receive. The distinction is decisive. Camilla's children gain no constitutional inheritance. A possible private inheritance remains unknown, and the word inheritance cannot convert institutional assets into family property. History provides guidance, but not a script that the next reign must follow. 4 royal widows reveal 4 different combinations of title, family relationship, residence, and public work. None gives a complete forecast for Camilla. Queen Adelaide supplies the closest comparison on one narrow point. She was the widow of King William IV when Victoria succeeded in 1837, and she was not the new sovereign's mother. A parliamentary record from that year called her the Queen Dowager. The similarity is clear. A widowed consort remained identifiable as a queen under a new monarch who was not her child. But Adelaide lived in a different constitutional and media environment. Her example predates the modern royal household, the sovereign grant, contemporary security systems, and the current Regency Acts. It can support the historical category. It cannot settle a modern communication style, a London residence, a staffing budget, or Camilla's future schedule. The document answers what a royal widow could be called, not everything she could receive. Queen Alexandra adds a different piece of evidence. After Edward VII died in 1910, she continued to be known as Queen Alexandra, while Queen Mary became the current queen beside George V. The London Gazette distinguished the two women in the same official publication. Alexandra also returned to Marlborough House and remained associated with it until her death. That example disproves the idea that a new queen must erase the widow's royal name. It also shows that a residence may continue under a new reign. But Alexandra was the new king's mother, and the practical arrangement belonged to a specific family, property, and era. Her continued use of Marlborough House does not create a transferable right to Clarence House for every future royal widow. A precedent demonstrates that something happened once. A legal entitlement proves that it must happen again. The Alexandra evidence is the first, not the second. Queen Mary broadens the timeline. She became a royal widow when George V died in 1936. She retained the style Queen Mary through the brief reign of Edward VIII, the reign of George VI, and the opening of Elizabeth II's reign. The Royal Archives preserves records of her engagements from 1936 through 1951, showing that widowhood did not automatically end her public activity. Mary's longevity in public life matters because it separates the current consort's office from a continuing personal role. She was no longer the wife of the reigning sovereign, yet she remained visible and active. Still, her relationship to the later monarchs was unlike Camilla's relationship to William. Mary was mother to 2 kings and grandmother to Elizabeth. Her place in the direct royal line gave her a family position that a stepmother does not share. The useful principle is continuity by arrangement. The unsupported leap is that Camilla must receive the same prominence. The most familiar precedent is also the easiest to misuse. Queen Elizabeth, the widow of George VI, adopted the public form Queen Elizabeth, the Queen Mother, after her daughter became queen. Her official biography describes a long continuation of duties, more than 40 official overseas visits, and associations with approximately 350 patronages and organizations. She moved to Clarence House and privately acquired the Castle of May. At first glance, that appears to answer every question in Camilla's favor. A royal widow kept a title, a residence, staff, public duties, charities, and major visibility. Then, the constitutional difference changes the result. Elizabeth was the mother of the reigning sovereign. The words Queen Mother described a relationship Camilla does not have. Parliament also needed the Regency Act of 1953 to restore Elizabeth by name as a Counsellor of State. Her prestige did not preserve that statutory function on its own. Her property story is equally instructive. Clarence House was an official residence made available within the royal system. The Castle of May was a private purchase. Placing those 2 homes in one biography does not make their legal status identical. One illustrates institutional accommodation, the other illustrates private ownership. That is exactly the separation any investigation of Camilla must preserve. Across the 4 cases, a pattern appears. Widowhood did not erase the women's titles or require them to disappear from public life. New reigns found ways to distinguish the current queen from the previous king's widow. Residences and duties could continue. Public respect could remain substantial. The limits of the pattern are just as important. 3 of the women had direct maternal relationships with the new sovereigns. Their homes followed different legal arrangements. Their public programs varied. Only the Queen Mother received a special statutory restoration as a Counsellor of State, and Parliament had to create it. No historical case gives Camilla an automatic budget, an immutable residence, or a guaranteed place in William's working household. History therefore supports continuity as a possibility, not continuity on identical terms. It makes the image of instant erasure less credible, but it does not authorize the opposite fantasy in which nothing changes. Camilla may remain a Queen Dowager with selected public service. How much service, which home, what support, and what prominence are questions for the future reign and the legal arrangements behind it. There is one alternative path. If William became king after an abdication, Charles would still be alive, and Camilla would not be his widow. The Queen Dowager analysis would therefore not apply. The instrument and legislation governing the abdication, Charles's continuing style, and the arrangements made for both spouses would all become relevant. The abdication of Edward VIII also warns against assuming that rules designed for death produce the same result when a sovereign voluntarily leaves the throne. That different path deserves a separate investigation rather than a footnote disguised as certainty. We can now deliver the final verdict in 5 clear parts. What changes automatically? William becomes king as soon as Charles's reign ends through death. Catherine becomes queen consort, assuming the marriage continues. Camilla stops being the reigning sovereign's consort, and her qualification as a Counsellor of State through marriage ends. None of those changes waits for the coronation. What does precedent suggest? Camilla fits the best-supported historical category of a queen dowager and may retain queen within her public style, selected charitable work, and a respected place at major occasions. History makes those outcomes plausible, not compulsory. What could William influence? Together with the new royal household, and within the relevant legal and administrative rules, he could shape Camilla's official duties, public prominence, staff support, patronage review, and use of official accommodation. He could help continue a role, reduce it, or bring it to a dignified close. What remains unknown? Her exact public style, future residence, continuing role, institutional funding, private provision, and protective security arrangements. Those answers require future announcements, valid property documents, or private estate records that the public does not possess. What is unsupported? Claims that William has a proven plan to erase Camilla's history, seize her private assets, strip away every legal right, or banish her from Britain. The allegations offer a villain and a victim before they identify an authority, a document, or even the correct property owner. Her place in history as Charles's queen consort would remain, while her public style in the new reign would still require an announcement. Her statutory eligibility as the sovereign's spouse would end. Her institutional future would be shaped by the new reign, and her private rights would continue under the law. William can reorganize the monarchy he inherits. He cannot turn that institution into personal ownership of Camilla's title, home, money, or liberty. That is the answer hidden by the dramatic headlines. Camilla loses one clearly defined legal qualification and the central role of the current consort. She does not lose her past, and she does not automatically lose every element of her future. Where the law speaks, the change is immediate. Where history guides, the result is possible. Where a future household must decide, the answer remains open. And where a viral claim supplies no document at all, royal proof will not replace missing evidence with a louder story. The next royal proof investigation asks a question that even major news organizations still phrase incorrectly. Is Camilla the queen, or is she the queen consort?